Mississippi has one of the least regulated tenant screening environments in the entire country. The state's regulatory philosophy strongly favors property rights and minimal government intervention in the landlord-tenant relationship. If you're screening tenants in Mississippi, the federal FCRA and Fair Housing Act are essentially your complete compliance framework. The state has not enacted meaningful additional restrictions on any aspect of the tenant screening process. Let's start with application fees. Mississippi does not cap application fees. There is no state statute limiting what a landlord can charge for tenant screening. Mississippi does not have a comprehensive residential landlord and tenant act. The state is one of only a few that has not adopted a version of the Uniform Residential Landlord and Tenant Act. The landlord-tenant relationship is governed primarily by common law, limited statutory provisions, and the lease agreement. None of these sources address application fee amounts or procedures. Most Mississippi landlords charge between $15 and $35 per applicant, on the lower end of the national range, reflecting the state's affordable rental market and lower average incomes. Charging fees significantly above this range can discourage qualified applicants in a market where many tenants have limited financial resources. Criminal history screening in Mississippi is completely unrestricted at the state level. Mississippi does not have a ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to look-back period limits. No Mississippi municipality has enacted local criminal history screening restrictions for housing. Jackson, Gulfport, Biloxi, Hattiesburg, South Haven, and every other Mississippi community operate under the same unrestricted framework. The screening environment for criminal history is entirely uniform across the state. Mississippi's expungement provisions are more limited than many states, but some offenses are eligible for expungement under Mississippi Code Section 99-19-71. Once a record is expunged, landlords cannot consider it in screening decisions. Landlords should verify that their screening provider filters expunged records from reports. Mississippi has not legalized recreational marijuana, though the state approved a medical marijuana program. Landlords should be aware that marijuana possession remains a criminal offense in Mississippi outside the medical program, but should also be thoughtful about how heavily they weight minor possession records as screening criteria, given the evolving national landscape. HUD's 2016 guidance on criminal history and disparate impact applies in Mississippi. The state has a significant African American population, approximately 38% of the state's total population, one of the highest proportions in the nation, and criminal history policies that disproportionately affect Black applicants face particular scrutiny under federal fair housing law. Blanket rejection policies that cannot be justified by a legitimate business necessity create substantial federal risk in Mississippi, specifically because of the state's demographics. Documenting your criteria and applying them consistently, considering the nature of the offense, time elapsed, and relevance to the tenancy, is not just good practice in Mississippi, it's essential federal compliance. Source of income protection does not exist at the state level in Mississippi. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. No Mississippi municipality has enacted a local source of income protection ordinance. Participation in voucher programs is entirely voluntary. This is practically significant because Mississippi has one of the highest rates of poverty in the nation, and a substantial portion of the rental population receives some form of government assistance, including housing choice vouchers, Social Security, disability payments, and temporary assistance for needy families. Landlords who exclude all applicants receiving government assistance significantly narrow their applicant pool in many Mississippi communities. While participation in voucher programs isn't legally required, the market reality in much of Mississippi is that government-assisted tenants represent a large and often reliable segment of the available applicant pool. For credit reports, Mississippi follows standard FCRA requirements, permissible purpose, written consent, and adverse action notice procedures. Mississippi does not impose any additional state-level requirements for credit report access, adverse action content, or notification timelines beyond the federal baseline. One practical consideration for credit screening in Mississippi: the state has lower average incomes and higher poverty rates than the national average. Credit scores across the state's population tend to be lower than national norms, not necessarily because applicants are poor risks, but because the economic conditions broadly affect credit profiles. Setting credit score thresholds that are calibrated to Mississippi's local market conditions, rather than importing national standards, ensures you don't exclude otherwise reliable applicants. A credit score that would raise concerns in an affluent suburb may be entirely typical for a stable, employed tenant in Mississippi. Mississippi's fair housing protections are limited compared to most states. Mississippi does not have a comprehensive state fair housing law comparable to what exists in most other states. The state relies primarily on the Federal Fair Housing Act for housing discrimination protections. The federal protections, prohibiting discrimination based on race, color, religion, national origin, sex, disability, and familial status, apply fully. But Mississippi has not enacted additional state-level protections covering categories like sexual orientation, gender identity, marital status, age, or source of income. The lack of a comprehensive state fair housing law means that enforcement relies more heavily on federal agencies, primarily HUD and the Department of Justice, and private causes of action under the Federal Fair Housing Act. Tenants who believe they've been subjected to discriminatory screening can file complaints with HUD, which investigates and can refer cases for enforcement. Despite the limited state framework, federal fair housing enforcement is active in Mississippi. The Department of Justice has pursued fair housing cases in Mississippi, and HUD investigates complaints filed by Mississippi residents. The absence of state-level enforcement doesn't mean the absence of enforcement. Federal agencies fill the gap. From a practical standpoint, Mississippi has one of the most affordable rental markets in the country, with moderate to soft demand in most communities and specific dynamics in a few key areas. Jackson, the state capital and largest city, has the state's most active rental market. The economy is driven by state government, healthcare, including the University of Mississippi Medical Center, the state's only academic medical center, higher education, including Jackson State University and Tougaloo College, and professional services. Jackson's rental market is affordable with moderate demand. The city has experienced population decline within the city limits, while the suburban communities of Madison, Ridgeland, Brandon, Pearl, and Flowood have grown. Screening in Jackson requires attention to the diverse applicant pool. The city has a predominantly African American population, and criminal history policies must be carefully applied to avoid disparate impact issues. Documented, consistently applied criteria are essential for Jackson landlords. The Gulf Coast, including Gulfport, Biloxi, Ocean Springs, and Pascagoula, has a rental market influenced by the military, Keesler Air Force Base in Biloxi, and the Naval Construction Battalion Center in Gulfport. Tourism and gaming, the Biloxi Casino Corridor, shipbuilding, Ingalls Shipbuilding in Pascagoula is one of the state's largest employers, and healthcare. The military presence at Keesler AFB generates significant rental demand, and military tenants provide reliable and verifiable income. Landlords should understand military income documentation, leave and earning statements, and BAH rates. Gulf Coast BAH rates are moderate. The Gulf Coast's hurricane risk is a constant factor. The devastating impact of Hurricane Katrina in 2005 fundamentally reshaped the region's housing stock and rental market. Landlords in the Gulf Coast region should maintain adequate insurance, including wind and flood coverage, and factor disaster risk into their property management strategy. Screening applicants who have been displaced by natural disasters requires sensitivity. Gaps in rental history attributable to hurricanes are common and entirely beyond the applicant's control. Hattiesburg, home to the University of Southern Mississippi, has a student-influenced market. The university's enrollment creates seasonal demand and applicants with limited credit and rental history. A consistent cosigner or guarantor policy is essential. Camp Shelby, a major National Guard training installation near Hattiesburg, generates some military rental demand, particularly during training exercises. South Haven, Olive Branch, and the DeSoto County communities in the Memphis suburbs have a rental market heavily influenced by the Memphis, Tennessee economy. Many residents commute to Memphis for work. This market is more suburban and family-oriented, with steady demand and moderate pricing. Oxford, home to the University of Mississippi, has a tight, student-driven market. Ole Miss's enrollment creates strong seasonal demand and high turnover. Starkville, home to Mississippi State University, has a similar dynamic. Columbus, near Columbus Air Force Base, has a military-influenced market. Meridian, near Naval Air Station Meridian, similarly sees military rental demand. BAH rates at these installations are modest. Tupelo, Vicksburg, Greenville, Clarksdale, and smaller Mississippi communities have affordable markets with limited demand. The Mississippi Delta region, including communities in Washington County, Bolivar County, and Sunflower County, has some of the softest rental markets in the country. Population decline, limited economic opportunity, and high poverty rates constrain demand. Landlords in Delta communities face the challenge of finding any qualified tenants in a very small and economically challenged applicant pool. Setting realistic screening standards is essential. Criteria that work in Jackson or the Gulf Coast may exclude virtually every applicant in a Delta community. One best practice for Mississippi landlords: because the state has essentially no screening regulation beyond federal law, your written screening policy is your most important compliance tool. Document your criteria: credit score threshold, income-to-rent ratio, rental history requirements, criminal history evaluation standards, and how you handle applicants with limited credit history. Apply those criteria to every applicant uniformly without exception. In Mississippi specifically, given the state's demographics and the heightened federal fair housing scrutiny that comes with having a large minority population, consistent, documented screening practices are your strongest defense against a discrimination claim. Another best practice: calibrate your screening criteria to Mississippi's economic reality. The state has the lowest median household income in the nation. Setting income-to-rent ratios and credit score thresholds based on national averages will disqualify a disproportionate number of otherwise reliable applicants. Research the specific market where your property is located and set criteria that identify genuinely high-risk applicants without excluding the working population that represents your actual tenant pool. A third best practice: for landlords who serve communities with high concentrations of government-assisted tenants, develop a clear and consistent approach to evaluating these applicants. Even though Mississippi doesn't require landlords to accept vouchers, many Mississippi landlords find that voucher tenants provide reliable rent. The housing authority pays its portion directly and on time, and the tenant's portion is typically modest. Evaluating whether to participate in the voucher program based on the business merits rather than blanket exclusion can expand your applicant pool and provide stable income. Mississippi does not have a statutory cap on security deposits. The deposit amount is governed by the lease terms. The deposit must be returned within 45 days of the tenant vacating. While the flexibility on deposit amounts provides financial protection, thorough screening remains the most effective tool. The cost of evicting a problem tenant in terms of lost rent, legal fees, and property damage far exceeds any deposit. For the complete guide to Mississippi tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.